Hello everybody, Ryan Chenevert with Fletcher Roy and Chenevert in Baton Rouge, Louisiana, here today to tell you about your rights as a client of a personal injury attorney. Now, unless you went to law school, injury law is new to you. The procedures and laws may have just as well been written in Chinese, so you place all of your trust and confidence in your lawyer and hope for the best. That's okay. That's okay if you've known your lawyer for a long time and you trust him. But what if you found your lawyer in a phone book, TV advertisement, or a billboard? Can you trust him? How do you know if your lawyer is telling you the truth? Getting straight answers from your lawyer is not easy. Hell, just getting your lawyer on the phone is often hard. So what can you do? Just throw up your hands and hope for the best? Sadly, that is what almost all injury victims do. But not you. It's time to level the playing field with your lawyer. There's just one way to do this. Learn your rights. If you don't have a basic understanding of your rights as an injury client, you will always be at the whim and mercy of your lawyer. But you don't have to be. I will give you the insider knowledge of the basic rights that few injury lawyers will tell you. It's simple and written in plain English. If your injury lawyer doesn't give you these rights, it's simple. Fire him. This is the first step to getting the justice that you deserve. First, you have the absolute right to fire your lawyer anytime and with no explanation necessary, even at trial. That's right. You can fire your lawyer whenever you feel like it. No explanation or apologies are needed. Heck, you don't even have to speak with your lawyer if you don't want to. Send him a letter. You do not even need to sign a piece of paper to fire your lawyer. All you have to do is say, "You're fired." Your lawyer may grumble and moan, but too bad. You entrusted him with your injury case, and if you didn't get everything you expected, you shouldn't hesitate to find a new lawyer. A retainer agreement is your contract that you signed with your lawyer. Yes, it's that document that you signed probably at the first or second meeting with your lawyer. Your retainer agreement sets forth your rights and obligations with your lawyer. Don't worry if you don't understand the retainer agreement. Most clients don't. They don't even read the retainer agreement. But here's the important point. You are not committed to your lawyer for life just because you signed a retainer agreement. You always have the exclusive right to fire your lawyer regardless of the fact that you signed a retainer agreement. You see, the retainer agreement does not force you to keep your lawyer. If you don't trust your lawyer and you want to switch lawyers, do it. Just like the Nike commercial says, just do it. The retainer agreement does not prevent you from firing your lawyer and you will not have to pay 2 legal fees when you hire a different lawyer for your case. At the end of your lawsuit, your new lawyer will split the legal fee with your first lawyer, but the total amount of your legal fee will remain the same. Second, your lawyer cannot fire you. This is a good one that you need to know, and maybe you should highlight this. While you always have the right to fire your lawyer with no explanation necessary, your lawyer cannot fire you after your lawsuit is filed. Your lawyer always has the right to decline your case before the lawsuit is filed, but that's no longer the case after your lawsuit is filed. If your lawyer threatens to fire you, and this happens all the time, trust me, you need to know one thing. He can't fire you unless you consent to the end of the lawyer-client relationship. Your lawyer must get permission from the court, it's called leave of court, to fire you as his client. The lawyer must make a motion to the court asking for permission to terminate his relationship with you. If you do not consent, the court may not allow your lawyer to fire you as his client. So keep in mind, if your lawyer tells you that he is ending his relationship with you, he can't do that. You have the right to say no. Third, you have the right to select the lawyer within a law firm who you want to work on your case. Let's say that you hire the world's greatest trial lawyer for your injury case, and you are happy with your selection of the best lawyer you could find. You go home with your retainer agreement in hand and a smile on your face. Everything's okay, right? Well, not so fast, my friend. Many of the top trial lawyers will meet and greet you at the first meeting. Several billboard attorneys or TV lawyers will do the same. But what happens next? You get passed off to the new associate just out of law school. Hey, all lawyers were there at some point in their career. And the new lawyers need experience too, but that is not necessarily good for your case. At your first meeting with your new trial lawyer, you must ask, will you be handling my lawsuit? Even better, you should ask, will you be handling the depositions and the trial? You need firm commitments from your trial lawyer. Or you might ask, if I have any question about my case, will you, Mr. Billboard attorney, Mr. TV lawyer, be available to answer them? Can I meet with you, Mr. TV lawyer, Mr. Billboard attorney, whenever I want? If your trial lawyer hems and haws when you ask these questions, it's a good bet that he intends to pass your case off to an associate at the law firm. Get these answers at the initial meeting and confirm your understanding with the letter which you ask Mr. Trial Lawyer to sign whenever you sign your retainer agreement. Number 4, you have the right to get a complete copy of your file at any time and without giving any reason at all. Your file belongs to you. It's not the lawyer's file, and you have the right to get a copy of the complete file whenever you want at no charge to you. In Louisiana, your file does not belong to your lawyer. It's yours, and you have the right to insist that you get a copy of the complete file whenever you want it. Your lawyer cannot ethically refuse to let you review your file. By the way, your file includes every document, whether electronically generated or a paper copy, relating to your case, including documents containing the mental impressions of your lawyer and his staff. If you are the client, you have the right to a status report about your case once every 4 to 6 weeks. If you don't know the status of your case and your lawyer won't tell you, it's time to find a new lawyer. You have the right to get answers from your lawyer in writing within a reasonable time of your request. You have the right to meet or speak with your lawyer within 3 to 5 business days of your request. Now, sometimes lawyers will be in trial, long extended trials, and their staff should inform you of that beforehand. If your lawyer will not meet or speak with you within that time frame, it's time to find a new lawyer. You have the right to a face-to-face meeting with your lawyer if you prefer a meeting instead of a telephone consultation. Number 5, you have the right to insist that you will not be responsible to reimburse the lawyer for case expenses, also known as disbursements, if you lose your case. You see all the time on TV, no fee guarantee. If we lose your case, you don't owe us anything, but you need to read the fine print. This means that nothing in a standard contingency fee would prevent the attorney from recouping his expenses. So in contingency fee cases like yours, the lawyer is not entitled to a legal fee if he loses your case, but he can recover the case expenses. Your lawyer will insist that you pay these case expenses or disbursements if he loses your case. Case expenses can range from $15,000 to over $100,000 in big cases. If your lawyer insists that you pay the case expenses at the end of the case that he loses, you could be forced into personal bankruptcy because there's no money to pay those expenses out of except out of your pocket. So it's not exactly a pretty picture you envisioned when you started your lawsuit. But there's great news for you. Your lawyer can agree in writing that you will not be responsible for the reimbursements of case expenses at the end of the case if he loses your case. You should insist that the retainer agreement that you sign with your lawyer contain a provision that specifically states that. I suggest writing if it's not already there. The client will not be responsible for the reimbursement of expenses incurred by his lawyer in the prosecution of the case in the event that there is no recovery by settlement or judgment. Only with such a provision in a retainer agreement will you be protected from a substantial debt at the end of your lawsuit? You should make sure your lawyer includes this paragraph in the retainer agreement. Otherwise, if you lose your case, you could be faced with personal bankruptcy. Number 6, you have the right to an itemized list of all case expenses, again called disbursements in lawyerese, from your lawyer at any time and without giving a reason. During your lawsuit, your lawyer will spend money for filing fees, expert witnesses, private investigation, and deposition transcripts in connection with your lawsuit. You likely will not even know when your lawyer spends money on your case, but I will let you in on a little secret. This is your money. You need to be very diligent on where your money is going. You want to make sure that these case expenses are being made properly and in the furtherment of your case and in good faith. Ultimately, at the end of the lawsuit, you will have to reimburse your lawyer for the case expenses. Yes, that is a little clause in the retainer agreement that you should read. So, you just might want to make sure that your money is being spent wisely by your lawyer. You have the right to a complete itemized list of the case expenses at any time. The list of disbursements or expenses will show the date of every case expense, where the money was spent to the payee, the amount of each expense, and the purpose of the expense. For example, a filing fee for summons, petition, or a complaint. It gets even better. You have the right to request a copy of each invoice that was paid by your lawyer. Remember, this is your money, and at the end of the case, you will pay these bills by reimbursing your lawyer. So, if you want to make sure that your money is being spent wisely, you should request an itemized list of the case expenses. By the way, you might also want to sit down with your lawyer to review the list of case expenses and the reasons for each expense. Number 7, you have the sole and exclusive right to determine whether you settle your case. Let's start with the very basic, irrefutable principle. You are the boss. You are the CEO. That's right, you make the decision on whether to settle, not your lawyer. Your lawyer is acting as your agent. And again, that's lawyer talk for he's acting for you. You're the boss. You're the CEO. Now, you can't go completely overboard. You will not dictate how to handle your lawsuit on a day-to-day basis. But when it comes to the ultimate decision whether to settle, I will only make recommendations for you. You can reject or accept my recommendation, even if it means ignoring my advice. Keep in mind, your lawyer cannot make the decision to settle, and he cannot force you to settle. Only you can decide whether to settle. Remember, you hired a trial lawyer. When you hired your lawyer, you had the right to expect that your lawyer was willing to go all the way for you, presenting your case at trial and letting a jury or judge decide your fate. If your lawyer is not willing to present your case at trial, he can be fired for cause, which means he will not get a legal fee. For your client, you have the right to a written evaluation of the strengths and weaknesses of your case from your lawyer. My written valuation of your case will have a monetary figure showing the absolute lowest amount that I will recommend as a settlement, the bottom line, and the figure that is the goal for the settlement negotiations. Your net recovery is the only number that should matter to you when you consider a settlement. Your net recovery is the amount of the check that you will receive after all expenses have been paid. For example, after deducting case expenses, legal fees, liens, subrogation claims. So, just to put it in perspective, your case settles for, say, $300,000. The case expenses are $20,000. The legal fee is about $80,000, and you have medical liens of $10,000. Well, your net recovery would be in the neighborhood of $185,000. This is what goes in your pocket, and this is the number that you should be concerned about. Liens and subrogation claims are ugly terms for plaintiff lawyers. When you have a long hospitalization, there is an excellent chance that you will be faced with a lien if the expenses were paid by Medicare or Medicaid. A lien is a claim usually by Medicare or Medicaid against your recovery from a third party, such as a doctor or hospital. against the expenses incurred for your medical treatment. Liens and subrogation claims must be paid from the portion of the recovery, and thus they will reduce the amount of your net recovery. Hence, you should be kept informed of the amount of the liens and subrogation claims throughout your lawsuit. Finally, number 8, you have the right to insist upon absolute confidentiality from your lawyer. You place a lot of trust in your lawyer. In some cases, clients have told me things that they would not tell their spouse. You have the right to insist that everything you tell your lawyer is strictly confidential, not just verbal communication, but all written correspondence and emails between you and your lawyer. Your communications with your lawyer and his staff are protected by the attorney-client privilege. This means your lawyer must keep his mouth shut about all the communications with you. If you question the integrity of your lawyer, or that he or she is not honest with you, you should terminate the attorney-client relationship. If your lawyer is not honest with you, it's time to find a new lawyer. If you believe that your lawyer has been dishonest, unethical, or lied, you should think about filing a complaint against your lawyer. The Committee on Professional Standards reviews complaints against lawyers and protects consumers against dishonest lawyers. Whether I'm your lawyer or you hired the lawyer next door, you should never hesitate to stand up for your rights when your lawyer isn't doing his job. I encourage you to aggressively protect your rights in your relationship with your lawyer. Make sure your lawyer is doing his job, and you will be head and shoulders above others in your shoes. Here's to your rights. Good luck, and I hope you have a successful claim.